Hello and welcome to another TCC video case report, this time covering the case of Blue Manchester Limited against Bug Alu Technic, the first defendants, and Simpson Hoare Architects, the second defendants. We don't need to go over the background facts of this case because this concerned an application by Blue Manchester Limited to strike out parts of Simpson Hoare Architects' witness evidence on the basis that they failed to comply with the new practice direction for the preparation of witness statements for trial, which came into force this summer. Now, this case actually follows on only a couple of weeks after the case of Mansion Place and Fox, in which Mrs. Justice O'Farrell sets out all of the relevant parts of the CPR, identifies what the old rules were and how it has developed into the latest practice direction. Now, I haven't done a report on that case because I think this one is a little bit more interesting because it develops those general extracts from the CPR and draws out particular themes, as well as applying those themes to 6 examples, which I'll go through in a minute. Now, just to go over some old ground here, under the old rules, the case was J.D. Wetherspoon's. That's what we followed. That's what provided the general guidance for what should and shouldn't be in a witness statement. For example, you shouldn't be providing a commentary on the documents or quote extensively from them in witness statements. You should keep to the issues in dispute, and you shouldn't include opinion evidence. But under the new rules, clearly the judiciary had got a bit tired of us continually failing to follow the general guidance and decided to become more prescriptive in terms of what can and can't be in the witness evidence. And we get under Practice Direction 57AC and the statements of best practice that's appended to it, very clear statements of what should go into these statements. So now, rather than just a general guidance as to covering the material issue in dispute, now it's clearly stated you can only include matters of fact that witnesses have personal knowledge of. Well, we knew that before, but it wasn't perhaps stated in clear terms. Also, now you have to identify what documents have not just been referred to in witness evidence, but also the documents that witnesses have referred to refresh their memories during the course of the preparation of witness evidence. And now a much clearer statement in the rules to say you can't quote, you can't argue the case, you can't use the witness statement to as an opportunity to take the court through the documents, and you can't comment on other evidence provided in the proceedings within witness evidence. Finally, all of this has to be underpinned by an amended statement of truth, which has to confirm understanding and compliance with the new practice direction and statements of best practice. Finally, even us lawyers now have to get involved to certify that, in our opinion, we think that the witness evidence that we may have assisted in preparing has complied with the new rules and guidance. Now, inevitably, this has led to open warfare in many cases over the last few months, and hopefully this case report will be helpful to those of you who find yourself in one of these bun fights. Now, in Mansion Place and Fox, the result was that minor amendments were ordered between the various witness statements, and the cost order in the case was costs in the case. But it was quite interesting because Mrs. Justice O'Farrell gave this guidance at the end of her judgment, which indicated that perhaps the court wouldn't want to hear very many of these after the first few months of this coming into force. This is what she said. Where a party is concerned that another party has complied with the practice direction in any particular respect, the sensible course of action is to raise that concern with the other side and attempt to reach agreement on the issue. Where that's not possible, the party should seek the assistance of the court by application for a determination on the documents or at a hearing. However, this should be done at a time and in a manner that does not cause disruption to trial preparation or unnecessary costs. The court does not wish to encourage the parties to engage in satellite litigation that is disproportionate to the size and complexity of the dispute. Often the judge will be best placed to determine specific issues of admissibility of evidence at the trial when the full bundles and skeletons are before the court. So here we have some reluctance, at least from Mrs. Justice O'Farrell's perspective, to engage in these sorts of applications to make these sorts of determinations. But we have a slightly different approach taken by His Honour Judge Stephen Davies in Blue Manchester. Now, the starting point here is that building on the new civil procedure rules and practice direction, Paul Darling QC, who represented Blue Manchester, set out 6 what he called overriding requirements with which trial witness statements must comply. And I think it's worth going through those here. First, they must, if practicable, be in the witness's own words and must not be expressed in the third person. Second, they cannot include opinion about the meaning of a document unless the witness's contemporaneous belief about the meaning of the document is a relevant issue in the case. Third, they cannot include argument. Fourth, they cannot quote at any length from the documents. Fifth, they must state which statements are made from the witness's own knowledge and which are matters of information or belief, and must state the source for the latter. Finally, they must state, if practicable, on important disputed matters of fact, how well they recall the matters addressed, and whether, and if so, how and when their recollection has been refreshed by reference to documents, identifying those documents. Now, Rachel Ansell QC, who was against Paul Darling in this case, made a number of submissions which accepted that these were general requirements, but said that they could be softened depending on the facts of any given case. Now, rather than go through those submissions, it's probably best to say that the judge here doesn't expressly approve Mr. Darling's 6 propositions, 6 overriding requirements. But I do get the sense that we will keep coming back to these 6 requirements in later applications based on this judgment. And it's only a matter of time before I think a judge pulls these together and makes and either expressly approves them or comes up with some different formulation. So I think as a rule of as general practice, if you're not going to be using the totality of the CPR and the practice direction, these 6 statements of principle are probably good ones to be starting with, extracted from the judgment. So, having gone through those, what the judge did in this case was went through what I've identified as 6 specific issues with the witness statements in this case that he determined, and hopefully it will be useful now to go through those 6 relatively quickly, read out to you the conclusion on each that the judge reached so you can get a sense of the tone and the approach taken by the judge in this case, and then I'll draw some conclusions. So the first argument was that these witness statements apparently included lots of narrative in the third person and general statements summarising the documents or a series of events. And from those generic descriptions, it was almost impossible, Blue Manchester said, to know whether those statements came from witnesses' own knowledge, information and belief. Now, Rachel Ansell said, well, it might be justifiable to draft in the third person in this way, where you have lawyers preparing various witness statements, and just as a practical measure, you're going to see some replication between witness statements if that's the case. Now, the judge took a pretty dim view of this, and this is his conclusion on this issue. In my judgment, this is a good example of the problems which arise when a witness statement is not prepared with the requirements of the relevant practice directions in mind. I'm prepared to accept that it's possible to make an educated guess that if a witness was asked about a particular paragraph, he would say it's made from some combination of his own recollection of events and his having referred to contemporaneous project documents. However, if the practice direction is properly followed, it ought not to be necessary for anyone reading these sorts of parts of witness statements to have to make an educated guess. So here, the judge came down on the side of having to make amendments to the witness statement to make sure that these matters were clarified. Well, what about the list of documents? Well, in this case, what the second defendant tried to do was provide a composite list of all the documents that had been referred to by the witnesses, but there was no way within that to identify which of those documents had been referred to by which witness. And unsurprisingly, perhaps, the judge here said that it cannot be acceptable in any view for a list which is not even referred to in a witness statement simply to accompany the witness statement. While there may be cases where a composite list could be justified, that would be the exception rather than the rule. Now, this is a really good indication of what the judges expect by way of compliance with these civil procedure rules. Yes, okay, you might, on the surface of it, comply if you just provide a list that goes together with your witness statements. But what is wanted here is a forensic level of detail where you're able, with a list appended to a particular witness statement, to identify what documents on what issue were relied on and referred to refresh a witness's memory, or even to give the direct evidence that has been given. So no shortcuts, I think, is the message here. Well, the third point that was made was, well, what about the statement of compliance? If a witness sits there and at the end, having given his or her evidence, says that they understand the requirements of the CPR and they think that they've complied with them, does that in some way make good any errors of drafting that may have gone before it? And again, in the same tone, the judge here rejected that suggestion. So paragraph 34, I don't accept that the witness is to be given the benefit of the doubt because he signed the witness statement confirmation of compliance. As Mr. Darling submitted, a witness cannot mark his own homework, at least not where it's obvious from the product of the homework that there is a real doubt whether or not the student has even properly attempted to answer the question asked. So again, here is the judge saying, I'm sick and tired of these witness statements coming in, not having complied with the old guidance. Now we've got the new guidance, and I want it to have some teeth. Well, the next issue was, what about the use of chains of correspondence within witness statements, where they simply recite a chronology and then provide a concluding comment? Well, this the judge deals with at paragraph 38. This, in my view, is a very good illustration of lawyers needing to be prized away from the comfort blanket of feeling the necessity of having a witness confirm a thread of correspondence, because otherwise it might in some way disappear into the ether or be ruled inadmissible at trial. So again, we've got into the practice of setting out a chronology in witness evidence and having witnesses confirm, yes, this is what happened. And the judge is here very clearly saying, no, the purpose of these new rules is to stop you from doing that, to make sure that we only get the material evidence from the witness and not some recitation of a chronology. Well, what about the requirement to state how well a witness recalls something? Now, this is something I personally have struggled to get my head around, but it is now a requirement. And I think it's worth reading out the totality of paragraphs 40 and 41 here from the judge, because it really does give you a sense of, again, where the judiciary is heading on this issue. I accept that the obligation to state how well the witness recalls the matters addressed and providing details of documents used to refresh memory is only in relation to important, disputed matters of fact, and is qualified by the words, if practicable. However, in my view, a witness cannot glibly assert that it is not practicable to comply so as to justify wholesale departure from this important requirement. If there's apparent non-compliance, the witness would have to justify why it is not practicable to do so. Miss Ansell suggested that it would be impracticable when a witness has also been asked to assist at earlier stages, for example in replying to a pre-action letter of claim or in drafting the defence. For myself, I do not see why a witness who's asked for such assistance by legal representatives and who is provided with or refers to documents for such purpose should be unable, at the point of producing the trial witness statement, to comply regardless of whether they had also previously been provided with or referred to those documents. Nor do I accept that a witness can rely on her own subjective view of what is important to avoid compliance. I also accept that the witness confirmation of compliance states that on the points that I understand important to be important in the case, I have stated honestly how well I recall matters and whether my memory has been refreshed by considering documents, if so, how and when. However, I'm unable to accept the argument that compliance with this requirement means that it's solely for the witness herself to decide whether or not a point is important. It is understandable that a witness can and should only be asked to certify compliance in relation to points which she thinks important. However, that does not mean that the court cannot intervene when it is plain that, in fact, there has not been compliance in relation to a point which is, on any objective analysis, important. So again, here we have yet another example where the wording in the CPR would appear to provide a get-out clause from having to comply with the strict letter of the requirement stated, but the judge is saying no. Here, where there is a clear failure to comply with that obligation, we're not going to let you off the hook. We are going to make sure that you comply with these requirements. The sixth and final issue that the judge covered here was the extent to which you can include argument, comment and opinion. Now, if you recall, this is an architect that's being sued here by Blue Magister, and it was said that when an architect is being sued for professional negligence, it's appropriate for them to respond with opinion and argument. But the judge took a very dim view of that as well. I do not accept that there is some principle that a witness against whom allegations are made, whether directly or indirectly, and whether in a professional negligence claim or otherwise, is thereby given carte blanche to disregard the practice direction by replying to the allegations in a way which includes argument, comment, opinion, and or extensive reference to or quotation from documents. And in blue here, I think this is really a neat conclusion which really helps to put yourself in the mind of the trial judge here and what they're thinking about when they come across witness evidence that goes too far and strays beyond the matters required by the practice direction. A trial witness statement is but one part of the material deployed by the party and available to the court at trial. The defence to the allegations will be pleaded. The allegations will be responded to in opening and closing submissions. Such submissions will also pick up the relevant material from the relevant documents, which address such allegations. In heavy cases, there may be some provision permitting the party at some suitable time to serve an additional chronological narrative derived from the documents, and trial witness statements suitably cross-reference to both, so that the judge can see how the party puts its case at trial. There may also be expert evidence in response to such allegations. In any event, there is no justification for the trial witness statements to respond to the allegations other than in compliance with the practice directions. So what we get there, trying to draw some conclusions from this, is that in the same way as we've had arguments initially over cost budgeting and then the disclosure pilot, and that resulted in a series of sort of satellite litigation. Now we're going to have a series of contested applications over witness statements. Now, if you're going to be contesting a witness statement, I think you've got to follow Mrs. Justice O'Farrell's directions and make that application almost immediately on receipt of non-compliant witness evidence, because to the extent that those applications may ultimately disturb the trial timetable, I don't think the judiciary is going to be very happy with that. But as long as you're making these applications early enough, then it looks from the approach taken in this case that the judges are going to be extremely hot on these issues and will want to try to use the coming months and years to change the culture that they're disappointed with in the preparation of witness evidence to date. The difficulty, of course, is that you may find that different judges take different approaches. Some will be pressed for time and won't be able to spend the time and effort on striking out anything but the most obvious and egregious breaches. Some may ultimately not enforce the spirit of the rules the way they've been drafted. But certainly from what you can pick up from this judgment is that there is the potential for the judges to become very heavily involved in an appropriate application, as I say, where there are several clear breaches of the protocol, and I expect to see many more cases like this in the future. Hopefully that you'll find that useful. If you do, please like it and share it, and subscribe on YouTube as well if you're enjoying these reviews.